Welcome to Law Made Simple. In today's video, we'll walk you through the complete process of filing a property partition case in India. Property disputes are a common source of tension in families, and knowing your legal rights is the first step to resolution. We'll break down the meaning of a partition, the documents you need, the legal procedure, and some practical tips to save time and money. Whether your dispute is about ancestral property or jointly purchased land, the process has a clear legal pathway. We'll cover each step in plain language so you can understand without legal jargon. Our goal is to make this topic easy to follow, even if you have no prior legal knowledge. So, let's start from the basics and move step by step through the process. By the end of this video, you'll know exactly how to file a property partition case in India. Introduction. Property disputes in India often arise when multiple people have rights over the same property. Sometimes, these disputes can be resolved within the family, but not always. When disagreements persist, legal action becomes necessary to ensure everyone's rights are protected. Filing a property partition case allows the court to officially divide the property into individual shares. This ensures that each co-owner gets their rightful portion. The process might sound complex, but it follows a structured legal procedure. In this video, we'll simplify each stage so you can follow along easily. Let's start by understanding what exactly a property partition means. What is a property partition? A property partition is the legal process of dividing jointly owned property into separate portions for each co-owner. It's most common in cases of ancestral property, where multiple family members inherit ownership rights. Partition can also apply to self-acquired property if it is co-owned. The division can be physical, meaning actual land or portions of a house are separated. Or it can be monetary, where one party compensates the other instead of dividing physically. The main goal is to end joint ownership and give each person independent rights. This process provides legal clarity and helps avoid future disputes. Now that we know the meaning, let's see on what legal grounds a partition can be claimed. Legal grounds for partition. A property partition suit can only be filed when the property is jointly owned by two or more people. Disputes often arise over the share each person is entitled to. In such cases, any co-owner can request a legal division. Partition is common under the Hindu Succession Act, the Indian Succession Act, and other personal laws. It applies when mutual agreement fails and one or more owners want a physical division of the property. The court examines the ownership documents to decide on rightful shares. It's important to note that personal and religious laws can influence the partition process. Understanding your legal ground before filing is crucial to a successful case. Step 1. Collect necessary documents. Before filing, it's essential to gather all the documents related to the property. This includes the title deed or sale deed, which proves ownership. You'll also need the encumbrance certificate, showing that the property is free of legal liabilities. Property tax receipts help confirm the property's legal standing. Proof of co-ownership, like a legal heir certificate or succession certificate, is also necessary. Having these papers ready speeds up the legal process. Incomplete documentation can delay your case significantly. So, make this your first and most important step. Step 2. Attempt an amicable settlement. Before heading to court, it's always wise to attempt a friendly resolution. Open discussions with all co-owners can save time, money, and emotional stress. Mediation is another option, where a neutral third party helps negotiate a fair agreement. In many cases, mediation can lead to a quick and peaceful settlement. This avoids the lengthy and costly process of litigation. If settlement is successful, you can document it legally to avoid future disputes. However, if talks fail, then you can proceed with legal filing. Courts also look favorably on parties who try to resolve the matter amicably. Step 3. Filing the partition suit. To begin, the case must be filed in the civil court where the property is located. Your lawyer will draft a written complaint detailing the property, the parties involved, and the relief sought. This plaint should clearly state the share you believe you're entitled to. Attach all supporting documents and evidence to strengthen your claim. Court fees must be paid, and these vary by state and property value. Once filed, the court will issue a case number and start the process. Proper drafting and filing can make a big difference to the speed of your case. So ensure you have an experienced property lawyer guiding you. Step 4. Court proceedings. After filing, the court issues summons to all parties involved. The defendants will file a written statement in response to your plaint. Both sides will then present evidence, including documents and witness testimonies. The court examines all submissions carefully to determine ownership rights. During the hearings, interim orders may be passed to protect the property from misuse. Once evidence is complete, the court will decide the share of each co-owner. This step can take time depending on case complexity. Patience is key as court proceedings often move slowly. Step 5. Final decree and execution. The court first issues a preliminary decree, declaring the share of each co-owner. Next, a court-appointed commissioner will physically measure and divide the property. If physical division isn't possible, the court may order a sale and distribution of proceeds. Once the division is complete, the court passes the final decree. This legally formalizes the partition and grants independent ownership. After that, mutation of property records in each owner's name must be done. This ensures that government records match the new ownership structure. With this, the legal partition process is fully complete. Timeline and costs. The time taken for a partition case can vary greatly. Simple cases may be resolved within a year, but complex disputes can take up to 5 years. The timeline depends on factors like case complexity, number of parties, and court workload. Costs include court fees, lawyers' fees, and documentation charges. Court fees vary by state and are often based on the property's value. Mediation or settlement can drastically reduce both time and expenses. It's wise to budget for legal costs before filing the suit. Being financially prepared can prevent delays and stress. Key tips. Always keep your property documents organized and updated. Consult an experienced lawyer who specializes in property law. Consider mediation as your first option before filing in court. Have a clear understanding of your rightful share before starting the process. Be patient. Property cases often take longer than expected. Avoid emotional decisions. Focus on legal rights and facts. Keep all communication with co-owners professional and documented. These simple steps can save you time, money, and stress. Conclusion and call to action. Filing a property partition case in India involves a series of legal steps, from gathering documents to filing the plaint, attending court hearings, and finally executing the decree. While the process can be lengthy, it ensures fair distribution and legal clarity. Whenever possible, aim for an amicable settlement to save time and cost. If settlement fails, the court process is your legal safeguard. Remember, every case is unique, and laws may vary slightly by state and personal law. Seek legal advice before taking any step. This has been Law Made Simple, helping you understand legal topics in a clear and simple way. If you found this video helpful, please like, subscribe, and share it with others who might benefit.